Roundtable, I'm going to very briefly introduce our speakers. On the far right is Joni Mason, who's an SVP and National Practice Advisor at USI Insurance. Joni's responsible for policyholder advocacy, coverage, and legal matters related to complex management claims, so right in the center of what we're talking about, including cyber claims. Joni is a Claims and Litigation Management Fellow, the CLM group. I know it's one of Diana's favorite groups. Was a defense lawyer and then did claims and underwriting at AIG, and now does the claims advocacy work at USI. Robin Reichman is to Joni's immediate left. Robin Reichman, I love this title, Robin. Global Specialty Claims Officer, is that right?
Sounds like what I got.
The Global Specialty Claims Officer at Aon. Robin also started as a lawyer in private practice and was named as among Elite Women 2022 by Business Insurance Magazine. And you know, I'll just tell you from my perspective as a coverage lawyer representing policyholders, you know when people like Robin and Joni are on the file, because we arrive later, when they're on the file, you know the client's been well served, at least as much as the client lets you serve them, because they're really experts at what they do. And I look at the D&O claims process as something of a continuum. Sometimes the claims get addressed with no pushing. Sometimes the broker claims advocate can help convince someone of the righteousness of the claim. Sometimes it takes lawyers. Sometimes it takes courts. But it's a continuum. To Robin's immediate left is Christy Weinstein. And Christy, thank you for joining us. Christy's the insurance risk manager for Honeywell Specialty Materials, which is in the midst of being spun off into a company called Solstice tomorrow. Tomorrow. So Christy's in the middle of an IPO spinoff. And I saw yesterday that immediately Honeywell's specialty chemicals, soon to be called Solstice, will be in the S&P 500 and will displace CarMax out of the S&P 500. So congratulations, and thank you for joining us in the midst of that kerfuffle. Christy's also a global board member of the Risk Insurance Management Society. And Christy, in addition to doing the insurance risk management, does enterprise risk management and risk engineering and works with professionals up and down the line. She's worked in a number of companies. We both got our start at McGraw-Hill. Christy's worked in a number of different industries, and for the people on the policyholder side, someone like Christy who's involved in RIMS and is involved in all facets of the insurance risk management process from within the corporate side is a really great person to know, and I suggest if you're doing that you talk to Christy, because she's really worth talking to. She's an expert in lots of the issues that you may be getting exposed to for the first time. Finally, on Christy's left is Grant Brown. Grant is a member of our insurance recovery group, and he represents policyholders in all types of insurance disputes, including D&O insurance disputes. And I didn't know this about Grant until I went and reviewed his background. But Grant is a summa cum laude law school graduate, and where he was an editor of the Law Review, as well as a cum laude college graduate. And I knew this about you. And Grant also clerked for the Maryland Court of Special Appeals. And when I want to warm my hands in the wintertime, I just hold my hands into Grant's head. There's a lot going on. So this is a great panel with probably a combined over 100 years of insurance experience. We have some topics that we'd like to discuss, but frankly, we're also happy taking questions if something we say triggers in your mind sheet. That's something that I'm seeing today, and I'd really like to see what these experts have to say. You've got expert lawyers, expert brokers, and an expert consumer, all here available for your questions if you'd like to raise them. Is that okay? Okay. The way we set this up, one of us is going to take kind of the lead on an issue. And Christy, the first issue that we have on our list was market update regarding acquisition and separation issues. And since you're in the middle of that, you're really familiar with what's going on there now. And why don't we kick off with that?
Yeah, I think, right now the market is ripe for a lot of new acquisitions and separations. What we've experienced with the recent separation from Honeywell is a lot of excitement for new IPOs. More in the market now than they have been. We're probably getting to a point where we're probably at pre-COVID levels, if I would guess. And a lot of discussion around what type of limits that we need and right-sizing them for an organization. So we're going from a $38 billion organization to a $4 billion organization that probably has a lot more risk on the regular operation side. But what does that mean for our leadership? And our leadership is, a lot of them are relatively, new. They're moving over from an existing role at Honeywell to a market-facing, organization where they're making a lot more strategic decisions for the operations, and our shareholders want to make sure that we're doing the right thing. So a lot of coaching going into leadership on what they're able to say and how they're presenting it, what kind of promises they're making in the market. And when we're looking at it from a separation perspective, it's also aligning the existing Honeywell programs with the new programs that we're placing and potential for any straddle claims, and how we're making sure that we're not going to miss or have any gaps in coverage, which we've experienced in the past with prior stints at Honeywell. So I think from that perspective, it's really working closely with your brokers and making sure that you have that specific wording on the policies, especially when you're changing, retention levels or limit levels to see which policies are going to apply and how you're going to work it. Overall, the market, I think, is very excited for new acquisitions and separations and new business in general. I think the rating environment has been a lot more stable than we've seen in the past. And, overall, I think it's a really positive environment for us right now.
I saw you nodding at the point you
Well, I was listening closely when Christy was talking about, the policy implications. She mentioned the word straddle. A lot of us, sit up straight when you say straddle language, which really means straddling two policies, right? If you're going through a transaction like this, in all likelihood.
The microphone closer. Can you move the microphone closer?
Is this the microphone
Yes.
or this?
The big one.
The big one.
Okay. I don't know.
Yeah, it's the big one, not the little one. Sorry.
Okay, take two. So straddle is what it sounds like, and oftentimes when a company goes through a transaction like Christy is describing, it will get what's called run-up coverage, so that the former T's and O's will have coverage. And you don't have to always do it that way, but sometimes you will have a go forward and a run-off, and you want to make sure that those two policies are working together. I mean, the gaps that you alluded to, can cause a lot of frustration and aggravation at the time of a claim, and so you want to get the wording right on the front end. It's very, very important.
And especially if your leadership is working in a specific way of which policy is going to respond and who's going to be responsible for the retention levels. And that was one of the biggest issues is who, you're going from high retention to a lower retention, but if you have the straddle wording, you want to make sure that you're aligning on who's paying what retention and it's going to impact it. Otherwise, it may be a larger impact to one organization than the other.
Tony, any comments on this, or is that pretty much it?
No, I agree wholeheartedly with what Rob was saying. You have to be careful and proceed that there's no gaps.
Okay, on the subject of gaps, One of the issues that does come up is our next topic, and that's notice-related issues. And this comes up in all insurance programs, comes up often in management liability programs, which, as you all know, are almost uniformly so on a claims-made basis. And Grant was going to describe, since we're lawyers, some of the legal frameworks that apply to that notice issue in claims-made D&O programs. Grant?
Thanks, Bill. So today's panel is discussing current topics in D&O, and notice is something that is going to always be current. Like Bill said, it affects any type of policy, it can affect any type of policy holder, and really it's a legal landmine to make sure you're providing proper notice. And just as brief background for the audience, although everyone probably knows this better than I do, D&O policies are what are called claims-made policies. So the trigger to coverage is the policyholder receiving a claim during the policy period in question. Notice provisions in D&O policies generally require that notice of a claim be reported to the insurance company, one, as soon as practicable, and two, but no event later than X number of days after the policy period ends. And that could be 30 days, that could be 90 plus days. It really varies policy to policy. So right off the bat, policyholders have two obligations. Notice as soon as practicable. What does that mean? Courts say often that it means a reasonable amount of time, which is also not helpful. But it's often a fact question. Fortunately, when we're talking about as soon as practicable, a number of courts, and I think a lot of policies now too, employ what's called the prejudice standard. So long as the insurance company wasn't prejudiced by notice that was provided outside of this reasonable time period, coverage won't be forfeited so long as the insurance company hasn't been prejudiced. Now, this is a little different with the second requirement that notice be provided within X number of days after the policy ends. Usually that is strictly enforced. So it's always important that the person, that the company that's responsible for insurance is aware of what claims are coming in. And to add a kind of wrinkle to that issue is what constitutes a claim.
Well, I was just gonna say, right?
Yeah.
I don't want to interrupt, but yes, you have to know what a claim is in order to know what to report.
Exactly, and the definition of claim can change from policy to policy.
And I think also you have to make sure you understand who's receiving the notice, because it's not just, hey, anybody, but a lot of times you can customize your policy to say it's the general counsel or the director of risk management, not just, I'm going to send it to Joe Schmo at the mailroom.
Yeah.
So there's a little bit of mindfulness that goes into that.
Right, I think a lot of times that can't be negotiated in policy language, correct?
And I think that what confuses some clients is that I'll hear clients say, well, we didn't notice this, we didn't send this to you because it wasn't a claim yet, and it wasn't in litigation. But a claim, you really, really have to know the definition of claim in your policy, because it can be any written demand for monetary, non-monetary relief. It can be an email, it can be a towing agreement, which we talked about, request for arbitration or mediation. And it's not just something that's in litigation already. So that's where I think a lot of our clients get really frustrated at this issue, because it would otherwise be a covered claim, but for the late notice. And it's something that courts do strictly enforce, except for, some jurisdictions require prejudice, but many don't.
So on that point, on the point of the scope of what a claim is, sometimes a client, the purchaser of an insurance policy might look at claim and think, I want the broadest possible definition of claim possible so that everything could be a claim. And there's some sense to that. But then when you're faced with the practical reality of, I got a phone call saying I am upset, and that happened in year 1, I get a lawsuit in year 3 that maybe pertains to something related to that same issue, is that really something you want to have given notice of? And are you willing, if you have that broad definition of claim, to deal with the reality that you're going to have to put in a lot of notices? What's the standard operating procedure today?
I glibly say, if you need a lawyer, then you should know it. You know, like, it really is about getting your defense cost coverage, right? So, you know, I'm sort of half joking that it is that you want to make sure from the time you really need to start defending yourself, and that can be like pre-claim, you know, investigations aren't, you know, always claims under our, you know, policies, and there are other types of pre-claim, I'll say matters instead of agree, because that's really something in the policy too, but, you may want to, you know, hire an attorney then, so that you can start preparing for what you think is the inevitable. This, you know, the notice is that you just don't want to get it in too late, right? Because, you know, many insurers will say, even though I would argue it's not in our policies, that defense costs that occurred prior to giving notice may not be covered, you know, despite all that as soon as practical and some leeways given in notice. We do have those sorts of discussions and conversations when there is some time between when a capital C claim is actually made, then notice, and whether there's, you know, sort of a time in between where there can be defense costs. And, you know, if it's $250,000 for defense costs, and you have a $10 million retention, you may not have a dispute. But if, you know, you got up and running pretty quickly and first notice and it's $5 million in defense costs, you know, a $2.5 million retention, I can assure you there will be a dispute.
I think it depends too, when you look at it from a materiality perspective, what you're talking about. And with large organizations, a lot of our stuff is handled in-house, so it's very difficult to say, okay, you're spent $250 on defense costs when you're still managing it internally without engaging external counsel. So there's a balance there too. What truly is a claim and what is it?
Well, it was a capital C claim, I say,
Yeah, of course.
because you don't have to worry, you can sleep at night. I mean, Joni said sometimes clients, you know, don't recognize that something's a claim because the definitions have broadened over time to include things that are not within litigation, like a tolling agreement. But we also sometimes hear, this is never going to breach the retention, ever, right? You know,
famous stuff.
it could be a $100,000 retention, it could be a $5 million retention, but everybody is so positive, right, that nobody did anything wrong, and you have to also remember that in our D&O policies, loss is not just defense costs, right? I mean, not just settlements, it's also your defense costs. So it could really have no merit, and maybe you settle for something nominal, but it may take you a lot of defense costs to get there, right? So I encourage everybody to, I need, you know, noticing anonymous, like, well, early and often, you know, you can't notice enough where people are not concerned. So.
As an outside counsel, if you ask me, should I get noticed, it is very hard for outside counsel to say no.
I'm a broker.
Because if you're asking, it almost answers the question, which gets back to the
I'll just 1 second, but we're overlapped, right? You know,
you're overlapping.
So, that's, you know, the broker's responsibility, right? If that turns out to be a big nothing, right, that it won't, because we also hear, well, I don't want it to affect my loss history and, you know, how underwriters view me, but, you know, in the financial line space, I do know that there's some truth to that in other lines of coverage. I think Joni and I exclusively do financial lines. And that is our broker, our counterpart's responsibility at the time of, you know, that renewal or the next renewal to say, you know, nothing came of it.
Right.
And there shouldn't be any sort of, nobody should be penalized for noticing. Like underwriters want to know, right? Early rather than
And I've often
surprise.
thought, and maybe the consumers and the brokers have a different view, I've always thought that the concern that giving notice of a potential claim or a small claim, that somehow is going to adversely affect the next renewal was something that, to say it's overblown is maybe minimizing what the clients are certainly feeling. But I think the reality of that situation is, if you turn it around, the underwriter could almost be thinking, I'm glad this client is actually on top of their exposures. And they're giving me the list of the few potential claims rather than not. And it makes me think they're better run. Is there any truth to that?
Yeah, I think there is. I think, you know, when you sit down with the underwriters, you tell the story, right? And they can talk about why they don't think it's gonna amount to anything, right? But as a claims person, you're always gonna say, I'm always gonna say, notice it, right? Better safe than sorry, like for a few reasons. One, you could have something that comes along, maybe this looks like nothing, but maybe a year from now, there is a lawsuit filed that relates back. If you hadn't noticed the first matter, then the second one's gonna relate back to a claim. And you'd be out of luck because of the
Because there's a related claims provision or something.
Yeah, because I don't know anything about workers' comp, but I'm just gonna talk as if I do. But I think like maybe in those other areas, there is some sort of like, where you can be penalized, right, for noticing? Did you take that into account?
No, I would say probably not workers' comp, because frequency is there.
Yes,
So
yeah.
they are gonna get $1 million workers' comp, depending on the size.
Right.
I think the one benefit of actively noticing, especially because it's a claims made policy, is you're securing one that's under that policy, right? So potentially if things evolve over the future, you don't want to have, you know, multiple losses under the same policy period and then potentially impair on its own thing. But at the end of the day, you can, if you secure it under historical policy periods before they expire, and then as you move forward, you're not going to have impaired on it for future things too. So in former life, right, where we had some more frequency of D&O claims, we would do notices, like a batch notice of everything right before the policy period, and so we're locking everything in prior to both on the D&O and American policies to make sure that you're, you know, securing the rights under those existing policies before you're going to.
I think you sort of veer off a little bit with like circumstance reporting,
Right.
Where, you know, it's a claim, you know, you're gonna have a choice, you're not really get to
Yes.
decide, you know, if you're gonna put a marker down under your policy, but with circumstance, that is a exercise that is worth going through. If you know of some things, right, there's language in the policy that most policies that will say, if you learn of something during this policy period, it may. Right, but you have to learn about it during this policy period, right? Like if you choose not to report it and nothing happens new related to that merit in the next policy period, I think there might be an argument that you can't put a circumstance in that next year. Because it says if you learn something during the policy period. So, you know, we're looking at the language and making sure, you know, if there is an ability to do that. I mean, I've been in the business now over 30 years. There was a lot of heartburn about noticing certain things. It was a sort of a gotcha effect because we have exclusions in our policies that say basically if something was noticed prior, it was related to it, you know, not covered by this policy. And so now we have,
And the practice.
we call it notice and accepted language, right? So that, you know, it really has to be accepted under that policy. It can't be that, you know, go forward. Or the next, the renewed program will say, well, you submitted notice, so you're out. That carrier has to have to be.
And one thing I've been noticing, I don't know if you've been seeing the same thing, is a lot of carriers, I think, maybe like 10 or 15 years ago, you could just notice something as a circumstance. And now they're being much stricter about what they will accept as a circumstance. You have to really have some details, like policy will say days, times, people involved, and why you reasonably think a wrongful act defined in the policy may occur. So they're not just accepting, I mean, we used to notice like attorney trolling notices as a potential claim. And now there's some carriers, not all, but some will push back on that and say, well, not enough information.
That issue is another example of how, and you see this a lot in the D&O area, because even though we've been doing it for decades, it's a relatively newish kind of insurance. It has a history where the notice of circumstance language at first was pretty broad and permissive, and you could notice things. into
One
policy.
list, yeah.
And then you run into those, I guess underwriters look at that and say, wait a second, why are we keeping these old policies open when there really aren't real circumstances or real claims? So let's tighten up that language.
And I would just add on that point, which I know I'm so far away from what you were talking about, sorry about that, but yeah, if you're going to change your primary carrier, or even anybody in the stack, you also want to think hard about whether, given the scrutiny that Jody was just talking about, circumstances, making sure that you've got good policy language on the go forward, about that notice accepted, but, it shouldn't be just, notice any circumstance that you have. It's a very, I think it's a very, communication is very thoughtful.
And it is something to involve an expert, particularly if you don't have expertise in-house. Involve an expert at your broker in how to think about these things, because it's not something you do willy-nilly. You actually want to think about, I'm going to change primary D&O insurance companies. What are the 23 implications of that and how I manage them? And speaking, it better even, sorry for saying this, better even than talking to outside counsel is talking to the expert broker whose job it is to actually put together those transitions when you have them.
Well, we do work very close.
Sorry, this goes back to the first point too, when you're doing a separation, it's very beneficial to keep the same primary carrier so that it avoids pointing.
And it does create stickiness, and I think the insurance companies know that. But it's a fact that parsing through a 150-page D&O program with 72 endorsements to make sure you don't have one of these gotchas is not for the faint of heart. And it really does require thinking. If you don't have expert risk management skills in-house, get them from someone outside.
I was just saying one thing about the notice. It's important that you notice, if you have an excess tower, you have to notice the entire tower, because that's another issue where I see clients say, well, it's not gonna probably won't reach their attention, maybe you can just notice the primary. That cannot happen. You've got to notice everyone. Again, it's not gonna penalize you, it's required. Sometimes the excess policies even have language that says, you must notice us at the same time that you notice the primary. And if we have clients that insist, if I have a client that insists, no, you may not notice the excess, I get that in writing and confirm, because that's an for me, if I don't do it.
Why would the client not want to notice the primary?
Because they have that same
Same
fear.
reason, yeah.
Fear that
Wait till they're up.
Yeah.
I don't see that as much on the dealing side though, like the impact on things like what we were talking about, but unless it's actually developed into something.
Insurance companies have a lot of questions, and not everybody likes to poke on it, So I do think it is sort of that annoyance factor a little bit, but I will tell general counsels, well, then you're just gonna have to have somebody else. You have to know.
Yeah, and it does come down to, if you want your insurance to function, comply with the conditions of the insurance. And if you don't mind having your insurance not function, well, okay.
And we will run interference, we able to deal with some of those issues that come up, lots of acknowledgement letters, things like that, questions.
I do think we have to think though with the nuance of, the nuisance communications, right? If you say this is a notice of an incident or notice of a potential claim, and you say there's not that much information, you're still gonna get information requests from your entire tower.
For sure.
The entire time. And then they're gonna follow up when you say there's nothing new to report. So you just have to be mindful, and a lot of risk managers are operating very leanly these days. So I would encourage senior leadership to expand their risk management departments, that's just me. But I think, overall, those nuanced, requests need to be mindful, and as much as you can rely on your brokers to support it, that's great, but a lot of times you'll have to see it come directly from the insurer.
I've seen that, and I do find this more so with the excess carriers, and especially with a large client where you have maybe you have a $10 or $20 million retention, and the excess will have it on diary. So it'll be like, it'll be like excess of $40 million and you get every 3 months, what's the status? But they're just documenting their file, so, I'll check with the client, they'll say nothing's happening, I'll say nothing's happening. Okay, but I know, and the clients sometimes do get agitated, but I'll just say, they've got on diary, right? So they're just doing.
And if you're an expert or have seen this process many times, you realize it's kind of like a game of tennis, where when that request comes in, you have to hit it over the net. And not let a request go unanswered for no good reason.
You just have to say, no, no,
So Brad, did we get to your legal issues?
Yeah, I should touch on it, because we were talking about claim community. Claim to be ambiguously defined, a written demand, shareholder demand letter, demanding that the company take some sort of action, limiting the possibility of warrant. You know, there's any claims issues, subsequent policy.
here?
That shareholder.
No, somebody's here.
Letter, might be trying to sue because the company didn't comply. And if the policyholder doesn't do that demand letter in the first policy period as a claim or doesn't see coverage for it, but wants coverage for the complaint filed in policy period 2, I can guarantee that the insurance company is going to argue that those claims are related. They go back to the first policy period because the policyholder didn't notice the claim in the original policy period. They'll use that as an excuse to avoid coverage. Now, there's going to be arguments around that depending on the policy language, but you're always in a better position to notice the claim, or if you need to squeeze it into a notice of circumstance as well, just to make sure you're protected on anything that could give rise to defense costs down the road.
Grant's comment about being guaranteed that an argument will come up shows that even though he's youthful, he can be cynical at the same time. And it does happen in this business, because you look and see, where are they trying to put the claim by using that related claims argument? Oh, they're putting it in the tower that's exhausted. It only happens every day. And that's where you see some of the most strained attempts to call something a related claim. So, interesting issues. We also had a separate category of the impact of notice in the claims process on risk managers and consultants. Did we deal with that already? One of the words that you all used when we were preparing for this was elasticity in notice. Yeah. And I hadn't heard that word elasticity in notice used that way before. What did you mean by that?
Well, you need some flexibility, right? Aon works with a lot of clients whose risk management function is not necessarily centralized, or even the legal function, or that legal and risk management may not, necessarily talking as much as we think. And so you want to make sure that if you stub your toe, that there is some flexibility in language. Christy mentioned something about materiality. We use the word prejudice. Again, Grant talked about how claims made in reported policies, which these policies generally are, can be very draconian when it comes to notice. Most of the states, the case law will say it is a condition preceded to coverage. And if you don't notice within the policy period, or whatever the grace is, 30, 60, 90 days post-policy, sometimes there's a drag. It has to be come in at the end of the policy to even get part of the grace. That you could, in talking about litigation, which we sort of affectionately refer to as company litigation, that would be that thing for state, right? And we're counsel if it didn't get in timely. And so we want to be able to try and say through contracts, which we can do, it would,
Words matter.
yeah, right? They would have to show material prejudice. So, not every client or every insurer will be able to offer that. Sometimes there would be additional premium, but it's a negotiation basically. But I would like to see that as often as possible.
And these issues, the more that you have words like material, the more you permit a factual argument, versus if you're required to give notice of the claim, and claim is defined to include, for example, I think you mentioned tolling agreements. And you have a tolling agreement Well, it's pretty clear, and unless I have elasticity in my notice requirement, I lose the flexibility I might otherwise have to notice something like that or not, because I think it's a mosquito bite, not something worth noticing. But
Totally agreement to sell in like a blink of an eye.
well, and I think the average professional outside of a group of well-informed insurance experts, the average professional might not think of a tolling agreement as a claim. They think of it as the opposite. It's actually someone saying, we're not going to make the claim, we're going to wait. So the policies that, having seen this, having seen the senior educated professionals be really surprised at the language in their own policies that includes tolling agreement as a claim.
And that's why I encourage clients like Christy to make sure that the general counsels, or whoever's in charge of litigation understands that. Because they're probably not, maybe some are, depending on the size of the company, at the meeting with Christy when she's negotiating alongside her broker, policy language and all of that. So I do find sometimes that the buyer and the end user aren't necessarily on the same page. And that can happen, off topic, but that can happen when choosing defense counsel. If there are panel counsel requirements between, there's one company, Love that has one of those. So.
And here, in this particular practice area of P&O claims, with an emphasis on securities actions, the counsel who are really good at defending big companies, it's a relatively short list, and their prices are relatively high, as they should be, bless them. But it means that you really want to make sure that you're getting good counsel. You don't want to be left with counsel you can get for $300 an hour when it really requires one of the biggest defense shops in securities litigation to adequately defend these cases. They're very complicated cases requiring real expertise. You should have real experts.
Yeah, but 2 points to that. One, following up on Robin's comment, make sure you read your policy. Because I know a lot of people don't. So understand that, and again, make sure your leadership understands it too, especially your DSNOs. If you have the opportunity to present to your directors and officers, take that opportunity out and really hone in on those details that they need to be aware of, because this is also their individual protections. And two, definitely engage your insurer on panel counsel. If you talk to your leadership and your legal counsel, your general counsel, or whomever, and say, who is your preferred counsel, and then negotiate that ahead of time.
Yeah. When you're holding a premium check is when you have leverage to do that.
Yes, absolutely.
So use it. The next issue we had was one of Robin's favorites, and that's derivative investigations and language issues and how that's working its way through the marketplace.
It was a favorite issue because Bill asked me at a time where I was engaging again in conversations, which is code for trying to resolve a dispute with an insurance company. And so that was the derivative investigations. And for those who aren't dabbling in D&O every day, like many of us up here, derivative investigations or derivative demands, I should say, we call them that to begin with, or could be a precursor to what is known as derivative actions or lawsuits. And those are lawsuits that are brought by shareholders on behalf of the company. I mean, I think we've thrown around the word securities class action here. Many probably know what that is, and that's where a shareholder feels that the company hasn't been forthright, whether it's a misrepresentation or admission, and when the alleged true facts come to light, the stock is impacted, and the shareholders will say that they've been aggrieved, they've been impacted, sort of their pocketbooks. They will bring a securities class action, and that is so that they can be recognized. Derivative actions are different, and that is really shareholders saying that the board, directors and officers, committed alleged wrongful acts that harmed the company. And we want the company to be, that's, through a monetary sort of damages award, or maybe corporate therapeutics. And so what this derivative investigations coverage is about, and it is sublimited for the most part under the D&O policies, gives you some part of the policy proceeds to use when you do get a shareholder derivative demand. In the industry, we've started, the insurers were very stingy with the sublimits, $250,000, and if you're using one of the firms that Bill just mentioned, it's going to go pretty quickly, and that has been like 250, 500,000 sublimit for these derivative investigation costs that have now, it's like a trough, right? And there's like a lot of pigs eating at that trough, because now it's books of records, and it's all the precursors to actually bringing derivative litigation. And so, point being is that can get used up pretty quickly. So, what we've started to do, Aon has built what we call these mini supplemented towers, and you can get, million, 2 million, as much as you can try and get up your tower, but you have to be able to get to it. And so that's the sort of the language issue here. There are some policies out there, the specimen forms that have not been endorsed, that would refer to a derivative demand as a shareholder making an allegation of misconduct on behalf of the board or its officers, and they can go through a litany of the most terrible sounding allegations. They used a plane for this, they took money here, and then at the end it says, and we want you to investigate. Instead of saying, we want you to look into this and bring suit, right, if you feel that that's appropriate, against the directors and officers for harm that they've caused the company. And what the policies will say is that a derivative demand, you have to have that bringing suit, against request in this derivative demand, or else you don't get into the supplement. So I think it's very important that we're taking a very close look at the language to make sure that, practically speaking, so everybody knows that that derivative demand letter that really only asks to investigate is a precursor to a derivative action, and that sort of the semantics around
But most people in insurance companies don't always acknowledge that. Yeah,
so
that's
and
true.
it's like the large loss exclusion, which is invisible, and so it's a very important issue, because if you have securities class action, you have a couple of these derivative demands out there, supplement is one thing, but you may want to try and settle everything at the same time.
And
if it's not being considered a claim at that time, you could be running into a problem when you try and settle that.
And there's a whole separate set of issues because of the nature of what's insured regarding derivative actions and whether or not it's legally permissible for a corporation to even pay for a settlement. In some states, like Maryland and Pennsylvania are two where you can, but
Indiana too.
Indiana.
I think so.
But in New York and Delaware, thou shalt not indemnify the settlement in a derivative case, which is against me, Mr. Director. So what does that mean? That means me, and this is one of the dichotomies of the D&O space. One, you've got limits available for the company to conduct my derivative investigation. But then you also have limits available for your board. And I, as a board member, want to make sure my limits are protected if and when a settlement has to happen in that derivative case. So that's one of those tactical issues in the midst of one of these complex claims that you need to be thinking about. And you may think differently about it depending upon where you sit. But usually most...
Larry has a comment.
Larry.
All right, I thought I raised my hand 20 times, I don't know the facts. But I really would appreciate knowing if anyone here is aware of a derivative settlement being identified by a company at any stage. I don't think that has or ever will happen.
It's legally
I
permissible.
don't think a court would ever approve a settlement, so it would happen.
I think I have. It would talk about all.
Yeah, I get that too.
Yeah.
Who's being made? Okay, so that's a derivative of litigation. And here's another new one. The SEC, and this is one of these issues, the impact of the SEC's recent change, I think this was the middle of September. The SEC commissioner came out and said, nothing in the federal securities laws prohibits companies from including in their bylaws mandatory arbitration provisions which would displace the ability to bring class action securities lawsuits. So that's a mouthful. And why is that even an issue? In the past, the SEC had been of the view that if you're going to file a registration statement with the SEC, we, the SEC, as a policy matter, are going to hold up your registration statement and not give you an early approval because you have one of these mandatory arbitration clauses in your registration that's identified in your registration statement. Now, the SEC has said that's no longer our policy. So what do you think about this issue, Al?
I think there's a misconception that arbitration is going to be cheaper and faster when it really is not. It's just as expensive. I think you'd rather be in court, and if you're doing individual arbitrations, it's going to become unwieldy rather than just having one class action. And I don't think I was at a pugnacity panel like you were at a few weeks ago, and the lawyers are not, the plaintiff's lawyers are not in favor of it. They don't think it's helpful. Defense attorneys feel the same way.
Plaintiff's lawyers I've spoken to about this issue have said, go ahead. Yeah, go ahead, we dare you. Because there are tactics they could use that end up not being any better than the class action defense.
Yeah.
If you have to defend an arbitration with 17,000 class members in it, which is what some of the well-heeled plaintiffs' law firms can afford to do, is that really where you want to go to avoid the class action world, where in arbitration land, as we all know from other areas, you don't get an effective right of appeal. So is that really where you want to be? And you don't get class action settlement protections that you would if a court so orders a class action.
Inconsistent outcomes, and race judicata, and legal terms of Aristotle, but how those outcomes, will be applied is not the same as it would be in a court of law, right, in arbitration.
And this issue because of our two-level set of regulatory requirements, both at the federal level and the state level, what the SEC said is there's nothing in the federal securities laws that prohibits it. However, the main incorporation state still today is Delaware. And as far as I know from talking to the defense counsel in Delaware, there's nothing in Delaware going on in Delaware today. There's nothing going on in Delaware today that's likely to change Delaware's approach. I think there's a policy approach in Delaware where they believe that class action litigation serves a purpose, and that permitting bylaws to include mandatory arbitration provisions probably doesn't foster that purpose. You know our lightning round?
Sure.
Forecast of the impact of AI.
On me personally? It's terrifying to me.
I think that terrifies everyone, and you look at it, it's in the news every day. And I think we have to be really mindful, and this goes back to the comment about how companies are presenting AI to the market and what promises they're actually making. I think that's one of the biggest things, and how that is going to turn into those promises and how they're actioning on them, and whether it's actually AI or not. And, is that going to have an impact on the operations of the organization? It's scary to me.
In the Dino claims world, those claims have happened. Companies being alleged to have done AI washing. A few years ago, it was greenwashing, and we've had, every time someone comes up with a new shiny technology, somebody discloses in their disclosure statements, we've got this new water engine, this new perpetual motion machine and it's going to make our company's revenues be great. Well, that's happened with a number of cases already. So you have one set of the disclosure issues. Are we accurately disclosing what we're actually doing in our business, saying that we're using AI? But then you also have, and this happens to be in the health insurance area, you have AI-based claims handling. So is it, and I think we're going to see this happen more and more and more, because the efficiencies, the efficiency imperative associated with assisting someone in handling claims is going to swamp some of the other requirements regarding claims handling in the insurance area. And there's several lawsuits pending now against health insurers, but I don't think it's going to stop there. So I don't think.
On the D&O context, right, you have like the AI washing, which is really the touting of your capabilities and how that makes you sort of better than everybody else. But you also have, which goes in the disclosure bucket, you know, how AI can impact the bottom line. So there's one securities class action out there that they were using AI, which was helping them be faster in one area, but actually that one area was sort of the higher profit margins. And so they didn't disclose how that might cannibalize some part of the business and then make them less profitable. So we saw those in the COVID claims also. You know, there was lots of companies who did very well, right? You know, whether it was bicycles at home or, you know, but as we were coming out of it, nobody was really saying what the impact would as people were returning to work or returning to their lives. And so those disclosures, you know, the impact on the bottom line are also very important, as much as I think the touting.
Are you seeing insurance companies try to draft specific provisions for AI? And if so, what do those look like?
I haven't seen that yet, but I'm sure it's probably in the works.
Well, there will be temptations, and just like a number of other exclusions went on the GL policy and went on D&O policy, many of them didn't hit the D&O program. Because when you stop and think about a management of wrongful act, which is what these policies cover, how can you take something that impacts everything and exclude it from the policy and leave what's potentially a place to argue about every claim?
I think this is, you know, I liken this to the whole ESG thing. And like, you know, management making promises to hit certain ESG metrics and then, you know, manipulating their data to support those promises. And so, you know, you're looking at that and saying, well, that happened, and now that's kind of what we're not really talking about ESG as much anymore, and now we're talking about AI. It's the same thing, you're just replacing one topic with another. And what are we doing to say that these metrics are going to be supported by AI activities when, how are you going to back it up? And how are you supporting that?
And then there's a separate sort of issue. This, Grant and I are both lawyers in a private law firm. And in our law firm, we've seen opposing briefs multiple times in the last year come in, and how could this be, given this is all over the press? I mean, from good law firms with hallucinated cases and quotations and citations. And you wonder, how could you possibly do this? But that's an error that would not happen but for AI, because it makes it too simple for human beings with all our frailties to do something that you really shouldn't do, and then say, oh, I did the work, and I filed this brief, and lo and behold, you've just done something that's awful for your client. So that's something, that sort of error, as AI becomes ingrained in everything we do, and people stop exercising judgment and permit AI to do the work without their judgment, I think we're going to see more, quote, wrongful acts in the D&O space that have, as part of their nexus, an AI.
Yeah, absolutely, and you're having, I mean, this is a leadership conversation too. How much are you relying on data that's coming from Copilot or, you know, ChatGPT or whatever? How much information is out there, and is that considered AI? Like, there's these large learning models that you're out there, you know, using to make management decisions. Now, is that taking away that management thought, or now are they relying on that as their expertise?
We should do another panel on this, because I think it's a right topic for the future. I'd like to thank all the members of our panel.